this matter. And before you this morning is the issue of two statutes and how they relate to each other and how they apply to this case. First, Chapter 382 is the chapter that governs vital statistics. Under Chapter 381, the legislature put the Department of Health in charge of the health of the state of Florida. And in that chapter, there's a specific duty that the department has to review records and protect confidential and exempt information in 381. And then that 381 also is the statute that promulgated and required the Department of Health to set up a separate vital statistic office. So we have 381 and then 382, and then we have Chapter 119, which is the Public Records Act. And the issue here has arisen because initially there was a specific request for death certificates in a time period of September 9, 2017 through September 16, 2017. And the death certificates were requested by the appellee through what amounted to a series of emails. And in that progression of those emails, the department stated that you can get those death certificates pursuant to Chapter 382, which is the vital statistics chapter. And there is a rule that the department promulgated that sets forth a procedure to do that. The Chapter 382 says that the department shall adopt and enforce its rules. And so that was the procedure that the department told appellees to follow. At some point in time, there was a issue about whether or not there should be an application, and the court said in a final judgment, the lower court said, you may be required to use the department's form and application. And so the appellee filled out a form, signed it, and asked for the death records for that week. The final judgment did not require the appellee to put the names of the 5,907 decedents. It just said you can use it.
Which they don't have, right? I mean, they're not in a position to do that. Those names have not been disclosed.
Well, there might be a possibility that they have names. I don't know that because it's not in the record. But
can I ask this question?
Sure.
I'm trying to make sure I understand what aspects of this appeal are procedural versus substantive. And so I know that the order on appeal, the sanctions order, said you were to produce these records and you could exempt or you could redact one field out of the death certificates, right?
Well, the order on the motion to contempt said that nothing could be redacted. It didn't even allow the department to review. It said you must produce...
Except cause of death field information.
Yes, the cause of death, Your Honor, is something that is actually almost always redacted. There's actually a separate application if you want or need the cause of death. Mm-hmm. Most times a certificate of death or a certified copy of a death record is so that you can use that certified copy in lieu of an original, take that and file it in a probate court, take that and give it to a insurance carrier for life insurance reasons. So it is as if it was the original statistic.
But my question, I guess, is and I know there's some disagreement about whether they should be able to request these en masse, but if they went through whatever procedural requirements the department argues they should have to go through, what body of data is it that they have sought, that the Department of Health believes it's required to produce, that it believes it should not produce? The order we're talking about exempts cause of death. My understanding is there's no disagreement about things like Social Security numbers. But on the substance of what is and is not legally required to be produced, where are the disagreements?
Okay. The only agreement is that the cause of death is confidential and exempt. That's
Okay,
the only.
where are the
agreement.
disagreements?
The disagreements are all the other personal identifying fields of information on
Like
the
names?
death certificate. Yes, Your Honor, the names, the social security number, the residence address of the decedent.
But if the request was properly made under 382, they would get all that,
They
right?
would get it, Your Honor, but it would be subject to accountability. It would be subject to consequences.
Well, they're subject to the felony consequences anyway if they misuse this information, right?
Not
I mean,
under the Public Records Act, they aren't.
they have to sign to be subject to the consequences of it?
Under Chapter 382, they sign an application. It's a form, and they have to identify who they are. They have to put their address on that, and they sign with that statement that says if you are obtaining this information for fraudulent purposes.
Well, you agree the final judgment of April 20 of this year by Judge Lewis is in fact final. You didn't appeal it, so that's law of the case, right?
Well, I agree that it's a final judgment. I agree that we didn't appeal it, but I don't agree that it was resolved all the issues and finished the case, because there was a lot left open to address, and the order of contempt materially changed what the final judgment said.
The amicus brief raised, and normally I think we wouldn't address things raised just by the amicus, but it goes to our jurisdiction. Is the June 19th order a final appealable order? It didn't say $100 a day fine. It didn't say somebody goes to jail. Is it in fact a final appealable order or a non-final appealable order? Do we have jurisdiction here?
Yes, Your Honor, because with that order, the court specifically said, no review, no redaction, end of the day, hand over the records electronically, and that to us was the actual final line for us is, wait, we have a duty to review, first of all, and secondly, if it's exempt, redact. And this court has just dropped the hammer down and said, no, you don't do that. You don't review and you don't redact.
It appears you're arguing that there are two avenues for seeking death certificates in Florida. So 382, where you fill out the form, you sign it, you pay the fee, you provide the name of the decedent. And then Chapter 119, which has a host of exemptions that the Department of Health must apply before disclosing that public record. Is there any avenue here where the appellees could request simply, I'm making a public records request for the names of all people who died between these dates? Would the names, in that case, if that was the only thing requested, would the names be exempt?
Yes, Your Honor, I think that would be an avenue to achieve, if that's what they want, is just the names. And again, the issue with just the names, if it doesn't have that personal identifying information of who is your surviving spouse, the mother, the names of your mother and father, I do think that's an issue for the trier of fact, because it pertains to whether or not that name is exempt.
And I understand that. So, and just to clarify, the record here is that they requested the death certificates, correct? They didn't request simply names of people who died. It was they wanted the death certificates of all persons who died between one date and another, correct?
Yes, which
Right.
which would necessarily include all of those fields, 17 plus fields that would have that personally identifying information. So what the department would do, if it was strictly through a Chapter 382 application, they would generate a document, and first of all, they would have to search, and then they would generate a document for each death with all of those fields filled in, print that out, and certify that that is as good as an original. And there's a fee associated with that. The fee includes the search fee and actually printing out that document. I think currently it's $10 per document. So,
But that, in that instance, if the person came in and did that and paid the fee and got this document, they would have What would be missing from that you're saying would be required to be produced under Judge Lewis's order?
Well, if they, Judge, going back just a minute, the final judgment had said the department may require you to use its form.
Right.
So that was the direction this was going. And so if that occurred, had they asked and pursued that.
I'm just asking about, just somebody walks off the street, has the name of somebody who died, and says, I would like a copy of this death certificate. I'll fill out your form. I'll pay your fee. What would be missing from that document that, under Judge Lewis's order, would be provided to, essentially, to the public, to the plaintiffs?
Okay, well, the cause of death would certainly not be there.
Okay.
Everything else
and everyone
would be.
agrees that, even Judge Lewis's order says not cause of death. But
Everything else would be, Your Honor.
everything else would be there.
Yes, but
Name,
the di-
address, surviving spouse, all the things.
All of those things.
Everything but cause of death.
Yes, Your Honor. But the difference between that and the 119 request is that if that person came in off the street and got that death certificate, they would be filling out an application with their name, their address. They would be signing it, attesting that they're not taking that information for fraudulent purposes.
I understand those arguments. I was just trying to make sure I understood the substantive data, what is available to the public under one avenue. And so there's nothing that Judge Lewis ordered you to disclose that would not be available through 382 in terms of information.
That is correct,
Okay.
Your Honor. Now, with respect to when it segued into the 119, something happened between the time of the application to get the records through 382 and then the subsequent May 7th invoice for the review and redaction. This is not in the record, so I can't speak to it, but something happened where it went the other direction into the 119 arena. And when it did that, the department was responsible, had that duty to review each and every one of those death certificate records to determine if something needed to be redacted.
Well,
It's
isn't that
very well-
exactly the essence? The final judgment cast these as records subject to disclosure under 119 and then directed you to comply with any future public records request, not a vital statistics request, but a public records request, correct?
Yes,
So
Your
at that
Honor.
point, this is a 119 proceeding.
Well, except in paragraph 3 of the final judgment, then the judge goes on this other path. I think the judge might have misunderstood the implication of saying you can do it under 119 and then saying the department can't require you to use its form under 382.
But isn't the problem, though, that you needed to have fixed it in the final judgment, challenged the final judgment up to us, sought rehearing on the final judgment, and when you didn't, right or wrong, you're stuck with the final judgment?
I would like to reserve about a minute and a half of my time, but to answer your question, Your Honor, is the issue of the review and redaction under Chapter 119 did not arise until the appellees decided not to pursue the 382. They had said, oh, well, we realize that under 382 we have to have the name. That's in the record and in an email. And the issue of the department's duty to review and redact did not arise until after the order of contempt was entered. If I may reserve the rest of my time. Thank you.
Thank you, counsel.
Good morning. May it please the court. Excuse my voice. I have a bit of a cold. I'm Tim Elliott, representing Rehab Center Hollywood Hills, the appellee. I'll refer to them sometimes as Hollywood Hills. In short, I think this is a simple case, and I just want to emphasize our main 2 points. And the first point is that there is a jurisdictional issue. The chronology here is that on April 20th, Judge Lewis issued his final judgment, which specifically held in favor of Hollywood Hills on all counts in the complaint, the 2-count complaints, mandamus and for declaratory judgment. And under that ruling, he was clear that except for the cause of death, these records had to be produced for the date range in question. And so that order was April 20th, and they did not file their notice of appeal until almost 2 months later. So
I'm looking at that order. Where does it say cause of death in that order? It certainly talks about it may require that petitioner request each death certificate by name, but I'm not seeing in the order where it mentions cause of death.
well, what he does say, and I may have misspoke, it doesn't use that precise language, but
Which order are we talking about now, the first one or the second one?
the first one,
Okay.
the final judgment, as it's called. He indicates in paragraph 2, the records requested are subject to the Public Records Law, Chapter 119, and no applicable statutory exemption to permit their withholding from release. So that's one part. And then in the ordered and adjudged, he rules in our favor on all counts. And above that, just before the therefore it is, on page 2, he says respondent must produce the applicable responsive records. And so then because he gave us judgment on both our accounts, when you look at the counts, we requested, except for the cause of death, we've requested all these death certificates for the 8-day period in question.
But I mean, you don't really do that in analyzing what a final judgment says. You don't go back and look at the pleadings. The final judgment says what it says, and if it's not clear enough, the parties needed to get some clarification or rehearing, something like that. So if the final judgment didn't say what you wanted it to say, we don't go back and look at the pleadings and say, well, you raised a cause of action for X, Y, or Z, right? We just look, the final judgment, look at the four corners of that, correct?
I think that's correct, Your Honor. But
Particularly with an injunction, right? I mean, it's a big deal to not comply with the court's injunction, and so there are legions of cases talking about how injunctions need to be precise and specific so that someone knows how to comply with it. And
right, and Judge Lewis later in his subsequent order on contempt said he had previously ruled that everything should be produced except for the records. They did not move for a rehearing on the final judgment if they were unclear what it meant. It was clearly argued during the hearing as well that...
But on the face of the order, it says there's no applicable statutory exemption, so you could read that to include the cause of death. I mean, there's nothing on the face of this order that says the department can, should or shouldn't redact, or whether the cause of death should or should not be disclosed. So my question is, how does contempt lie for noncompliance with that order?
How does contempt?
Right. How can the Department of Health be held in contempt for an order that is ambiguous on its face?
I just don't think it is ambiguous. I believe it's clear based on the arguments that were made at the time and the language that the judge used. And he later, in his contempt order, said that he had previously ruled that they had to produce the records except for the cause of death.
But
and
the
there were no
applicable
applicable exemptions. I'm sorry, Your Honor?
Go ahead,
Go
Judge
ahead.
Windsor.
Go ahead.
What does the final judgment do? I mean, it orders that, it's almost like an agreement to agree. You're ordered to comply expeditiously with any future request, or they are ordered to do that in substantial compliance with this judgment. But it doesn't say, by X date you will produce Y records, anything like that. I mean, you're getting someone held in contempt for not complying with the order, but there seems to be a lack of clarity there. What did the final order do?
I think it did just what I said. I think it was clear to everybody at the hearing and should have been clear from the language that they were to produce the documents.
Certified death records? I mean, the kind people would get under 382, or copies of them, or computer records, or what?
Certificate of death records. Certificates of death is what we requested in our complaint.
And doesn't that have a legal?
Certified?
Doesn't that have a legal meaning within the Vital Statistics Act under Chapter 382 and 381 as well?
Yeah, but I think one of the key points here is that I was going to get to in my second part of my argument, the substantive issues, if the court does not go with the jurisdictional issue. Substantively, what the department is trying to do here is make a dichotomy between, it's undisputed that anybody can go into a vital statistics office if they're one of these lists of authorized type persons, but it is basically any person can go in and request a death certificate or one or more death certificates, and without any, and just sign the application form. And by the way, we did later file the application form, so we are held accountable. But anyway, they can go in, any person, it's on their website, it's in other locations, and they've acknowledged it, it's undisputed, that anyone can go in and get the information that we requested.
But you requested it under 119, and it seems that you're trying to pick the best of both worlds. You want the attorney's fee recovery provision that's under 119. You want the certificate form and the applicable exemptions that are under 382. So is it the case that you get to, if you're going to request it under 119, so now the department ignores the legislature's express requirement that they redact particular information when you choose that avenue?
Well, I think those are two separate issues. For example, attorney fees. I believe that we have a right under the public records law, as Judge Lewis ordered, to request these records, and just like any individual can do.
Could any individual do that just to avoid the $10 fee? If I walked in and said I want, random, person's death certificate, and they said that'll be $10, could I just write out a 119 request and hand it over?
They still have to pay the fee.
I'm sorry?
They still have to pay the fee, and we were willing to pay the fees too. There was just a dispute about the fees, and we later did tender and pay the fees. And
Okay, so there's no issue about, at this point, about whether you'd pay the fees or not?
But no, I don't think so, Your Honor. And I mean,
I misunderstood that, then. I'm sorry.
I realize attorney fees are you get under 119, but I just think that's a separate issue, maybe to be discussed later. But
Well, the exemption issues are different. Under 382, if you choose that avenue, there are particular exemptions that apply to the information that's being disclosed in a death certificate versus records. And I think that's the point I was making with the appellant. Couldn't you have simply asked for records of the names of all people who died between X date and Y date under Chapter 119 without asking for the actual death certificates, which then implicates 382?
well, this gets into the motivation of why we were requesting these records. And as the amicus brief pointed out very well, motivation is not to be an issue.
I don't dispute that. That was not what my question was aimed at. It was the means of the request. Couldn't you simply have asked for the names rather than the death certificates, which then implicates Chapter 382?
We didn't have the names. Hollywood Hills, yes. So
Couldn't you have requested the names of
I
all
see.
people who died between a particular date under Chapter 119? What precluded you from doing that?
we could have done that, but we needed other information as well that would be on the death certificate, the address, the residence, for the purposes of what Hollywood Hills was doing, which was a defense of a separate case, and everyone's Hurricane Irma and what happened. They were expert witnesses were going to analyze the data to show that there was no, I shouldn't get into this, but anyway, there's reasons why we needed some of the not Social Security numbers without it. But it's hard to know what you're going to need, but the point is the motivation should not be questioned. We're entitled to the records under Chapter 119 as well as under 382. And a point that I was going to get to later is when you parse the statute in 382, the vital statistics key sections, they refer to Chapter 119, and let me get that in front of me. I think it's a good time to discuss that. I think the analysis here on the substantive issue starts and ends with Section 382.025 Florida statutes. That's the vital statistics chapter, and it's .025(2)A. And it basically says the department shall authorize the issuance of a certified copy of any death certificate and other certificates, excluding that portion which is confidential and exempt from the provisions of 119.07(1), as provided under Section 382.008. That reference to 119.071, which is, of course, the general public records law, but they say as provided under 382.008. Then you go over, and we've analyzed this all in our brief, but then you go over to 382.008. My apologies, let me get that in front of me. And look at subsection 6, and there it clearly says that the original certificate of death or fetal death shall contain all the information required by the Department for Legal, Social, and Health research purposes. Then it goes on to say that certain things, only limited things, are exempt. All information related to the cause of death and all death. Basically, the only thing that's exempt under this, which also speaks to Chapter 119, basically says the only thing that's exempt is the cause of death.
But counsel, both of these provisions that you just read to the court relate to death certificates, and death certificates are defined within 382, the procedures for requesting them, the safeguards that are in 382, all relate to death certificates. I think if you're making a request for records relating to death, that may be a different story, but you're using a term that has a specific statutory meaning and has specific statutory exemptions. So why shouldn't the department, when it receives a records request for 119, be obligated to comply with the legislature's direction that it redact particular information under the exemptions under 119?
I don't think, because this 382 controls over Chapter 119 as to this aspect, which is what Judge Lewis held, especially when you review the transcript of the hearing. Even though it's a Chapter 119 request, 382 refers to Chapter 119 in terms of what can be excluded from a death certificate and what cannot.
And what, in your view, can be? When you're talking about this 382.025, it says excluding the portion that's confidential and exempt under 119, what would that be, in your view?
Well, the only thing that can be excluded is the cause of death. It's just like I said at the beginning, any person can come in to the Vital Statistics Office, sign the application and complete it appropriately, and obtain a death certificate or multiple death certificates. So there should be no distinction.
Under this provision?
Under this provision.
But this provision would exempt certain things under 119.071.
Basically just the cause of death.
Would you agree that the June contempt order contains more detail and more requirements than were set forth on the four corners of the earlier final judgment?
I'd have to go back and look at that line by line. I think it does because it was a contempt order, but it also refers back to the original judgment and said that it had in fact previously ordered this to be done. I'm sorry, let me get back on I think my main point, Your Honor, on the substance of the issue is that just as Judge Lewis held, there should be no dichotomy between what an individual can come in and get, which is the entire death certificate versus what an en masse request can get, whether it's under Chapter 119 or 382. Any questions? That's really all I have. I rely on my brief at this point.
Thank you, counsel.
Thank you, Your Honors.
Just a couple things. Counsel referenced the transcript of the hearing, and on the department's appendix, page 48, there was a discussion about whether or not 382 trumped 119, and Mr. Williams, who I was remiss in introducing earlier, said at that hearing that 382 was silent with respect to the department's obligation to review and redact under 119.712, which is the department-specific exemption. And Mr. Williams said, and I don't believe that trumps, that the 382 trumps our requirements under 119. And the court said, I would agree with you. I don't think it trumps it either. And that's when the court just went off and said, well, to me, it's just silly and illogical that if they can get the records anyway, why I can't give them to them under 119.
And you're not disputing that at this point, right? I mean, that they can get them under 119. The question is, what's exempt, right?
I'm not disputing, we're not disputing that they can get them under 382 if they follow the procedure. If they ask for them under 119, we were required, the department is required to review each and every death certificate. The death certificates that we actually produce might completely, each one might look different than the other one because there might be certain information that's exempt in one death certificate that isn't exempt in another death certificate. Such as if I, as an employee of the state, wish that my information about where I live and who my surviving spouse is be kept confidential, there's a specific exemption in 119.071 that allows me that protection. And so, unfortunately, if I, die tomorrow and somebody goes in and asks for my death certificate, now they know who my surviving spouse is, they know, or if my spouse dies, they know who I am, they know where I reside, and so my information that I asked to be exempt is no longer exempt. So that's an example of what can happen. And it's just a small example. The larger issue here, I think, is the final judgment said that the department can't withhold the death certificates. There was never any intention to withhold a death certificate. And I agree with Your Honor that it was left open to interpretation. The final judgment didn't tell us really what we were supposed to do because everybody thought we were operating under 382.
Thank you, counsel. Your time's expired.
Okay, thank you.
Thank you all. This concludes our docket for today. This court will stand in recess.